Assalamu alaikum wa rahmatullahi wa barakatuh. Good morning. Welcome to the Islamic Central in California. We have a great guest and scholar, Dr. Khaled Abou El Fadl, on an important topic, the Supreme Court's Muslim ban, understanding our new Trumpian reality. So in this lecture, inshallah, we're going to find answers for the questions such as, what does this mean for Muslims? How does this new ruling impact immigration, travel, and separation of families? What does the Supreme Court decision really mean? So we're going to find the answers, inshallah, in this talk. And as you all know, Dr. Khaled Abou El Fadl is a professor of law and the Omar and Esmeralda Alfi Distinguished Professor of Islamic Law at the UCLA School of Law. And also he teaches political asylum and refugee law at UCLA, and also Islamic jurisprudence, political crimes, Muslims, race and law, and the trafficking of human beings, law and policy. So please welcome Dr. Khaled Abou El Fadl.
Assalamu alaikum. There is a lot to talk about. The Muslim ban. Well, first, we are all aware of the basic facts as to how the Supreme Court decision came about. President Trump, during his election campaign, makes a number of statements where he proclaims that he is in favor of a total ban on Muslims entering the United States. During the campaign trail, he promises repeatedly that if elected, he will put into effect a ban on Muslims entering the United States. And after he is elected, he comes out with proclamation number 1, or executive order number 1, proclamation, executive order. I'm going to be using these two expressions interchangeably, in which he lists a number of Muslim countries. Citizens of these countries are not allowed to enter the United States, and other details. There is an uproar, social uproar, political uproar, and a number of legal challenges. And then the first order by Trump is scratched, and we have the second proclamation with some basic adjustments that we don't really need to go into because at this point they're moot. And then the same process ensues. There are protests, and there are a number of legal challenges, and then the third revised proclamation. And again, with the third revised proclamation, the main changes in the third proclamation is that he removes certain countries like Iraq, Sudan, eventually Chad. The proclamation does not apply to permanent residents who have already gained their status as permanent residents, but it does ban the ability of a number of nationals from, for instance, Yemen, for applying for permanent residency in the United States, even if they have the legal status to do so. Anyway, we can talk about the sort of details, technical details later if you wish. But fundamentally, the third ban is, in essence, in terms of the idea, the mode of operation is basically the same as the first and the second. And as we'll talk about, there are a number of statements by the Trump administration in which he basically whines and complains that he doesn't like the way that the ban is now phrased, but that because of lawyers, he's had to cave in and to basically appease what he refers to as political correctness. And in turn, the third ban, the third proclamation is legally challenged, and the challenges are successful at a number of district court level cases and also successful at the Ninth Circuit level. And then it goes up to the Supreme Court. Now, the Supreme Court decision not just upholds the legality of the third proclamation, the third executive order, but as I'll talk about, it does much more than that. And the unfortunate, or the reality of law is that often in order to understand the legal implications of a court, an action by court, you have to have a sense of what the precedents are, what the body of law that is being interpreted is. And so the impact of the Supreme Court's decision upholding the Muslim ban is actually quite sweeping, as we'll explain. It's as the dissent points out, I think correctly, in this decision, that it establishes a precedent that does not bode well for Muslims in the United States, and puts some very serious challenges before us. But I'm going to emphasize the point that at the same time it is couched in language that is sufficiently technical that you can easily miss what is going on in the Supreme Court decision. In fact, the abstract or the syllabus published by the Supreme Court makes it sound as if we're talking about just yet another normal, run-of-the-mill immigration law procedure in which there is a basic presumptive ruling and then a set of waivers and exceptions, and that there is a process for simply vetting Muslims from certain countries more thoroughly than otherwise. And that's not true. I mean, although the Supreme Court does phrase the decision in these terms, so, you know, I can completely imagine someone looking at the Supreme Court decision and say, well, basically, there's going to be extra vetting for people from Libya, Syria, Yemen, North Korea, and Venezuela, and that's really what we're talking about. But that's not accurate at all, and that's what troubles me about this decision, because when law gets to be an instrument of misleading? No, law is always misleading. because law is technical, and that's the nature of law. But when courts use legalese to sort of cooperate in hiding hostile animus, then it becomes quite problematic, because a good lawyer can phrase anything in objective terms. And that's why lawyers are expensive. That's why you pay a lot of money to hire a lawyer, because their art, their skill, is to produce a technical language that makes things work within a legal process. Okay, so what precisely then goes on? Well, first, what the Supreme Court actually decides. The structure of Trump's third ban, and I'm not going to, because they're not relevant anymore, I'm not going to talk about the first or second ban, but we're going to focus on the ban that is law currently. The basic structure of the ban is that, as of now, Iran, Libya, Syria, and Yemen, citizens of these countries have a presumptive ban making them inadmissible to the United States. A funny part about the Supreme Court is the Supreme Court says, well, you can issue them visas, but you don't get to come in. Whatever. Okay, so moreover, the ban says that every 180 days, the Trump administration will review whether these countries have complied with a set of security demands made by the US government, and according to the language of the executive order to the third ban, that it is possible that after reviewing whether these countries complied with US demands for data sharing, intelligence sharing, approval of undeclared on-sites, and things like that, that at least in theory, it is possible that these countries would be removed from the list. Now, how about North Korea and Venezuela? Well, it's a little bit smoke and mirrors, because North Korea, it's on the list, but we actually don't have visa applicants from North Korea. Very, very few visa applicants from North Korea. Venezuela, again, smoke and mirrors, because Venezuela, there is a prior legislative act that had already banned individuals coming from Venezuela for most permanent visas. So in other words, it's clear that the only role that North Korea and Venezuela play in Trump's ban is to basically make it look like it's not just Muslim countries that are on the list, but legally, it's absolutely ineffective. Venezuela was already covered by another law, and North Korea, we don't have visa applications by North Koreans. For one thing, the North Korean government doesn't permit it. Okay, now moreover, according to the language of the third ban, the executive decision, that after considering, reviewing communications with foreign governments. Sudan used to be on the list and was removed, and Chad used to be on the list and was removed. Moreover, according to the letter of the proclamation, and it's about a 12-page proclamation, but it's not easy reading, there are a number of waivers made available which the government says it will consider on a case-by-case basis for people from these countries. So if you're from Yemen or you're from Syria, according to the executive order, then you can apply, you're banned as a matter of the executive order, but then you can apply for a waiver and say, you know, I have family in the US that I haven't seen for 20 years. They're called humanitarian waivers. And the Supreme Court looks at this and says, well, you know, when it comes to matters of immigration law, and when it comes to who gets to come into the country and who doesn't, we are talking about an area of law that is usually reserved for the executive and the legislative branches. They call this plenary powers, that the judiciary, in principle, should butt out when it comes to immigration law issues and let the executive and legislative branches do what is good for the country. And the Supreme Court said, well, you know, it looks like a reasonable legal process. There are countries that have certain weaknesses in their visa issuance processes or information sharing processes. So we have these countries on a list. Every 180 days we're going to review the status of these countries. And in the meanwhile, there is a waiver program for people to gain exceptions on a case-by-case basis. And the Supreme Court, in its 5-4 decision, in an opinion that was, I mean, it's shared by 5 justices, was 2 justices writing separately. We don't need to get into that unless you have questions about it. But Justice Roberts, basically, who's a Chief Justice, incidentally, writing for the Supreme Court, says, you know, this sounds like a very reasonable proclamation, a classic exercise of the powers of the executive in immigration and foreign policy matters. The Constitution, and not just the Constitution, but the courts should not be involved. And that's basically the basis for this decision. There's a long spiel in the Supreme Court decision, an argument whether Congress intended to give the executive that type of preemptory power, that type of expansive power when it comes to immigration law. And you know, we don't need to get into the sort of statutory argument, but basically the Supreme Court ends up saying, yes, Congress intended to give the president all this power. So how about the Islamic factor? How about all the anti-Islam stuff and all the virulent narrative against Muslims and Islam and banning Muslims and so on? Well, the Supreme Court says all of that is external to the record. The relevant record before us is the language of the law as articulated and as phrased if the law, in this case the proclamation by the president, is objective and neutral on its face. On its face means it sounds neutral. Then we don't need to look further. We don't need to consider what Trump might have said while while running for elections. We don't need to consider what Trump might have tweeted about Islam or Muslims. And all what we are going to consider is the actual phrasing of the law, and if it's neutral, then so be it. So this is a Supreme Court decision. Now, what is the problem with this? The problem is at many levels. Because much of what we read in the way that the Supreme Court described the law, meaning Trump's proclamation, Trump's executive order, which after this decision does become law and is law until changed, or if changed. The record in the actual case, and you have to understand that while Muslims are, sitting doing whatever Muslims do, a lot of people in this case, a lot of non-Muslim organizations and very important non-Muslim organizations filed briefs called amicus briefs in support of Muslims. In other words, against the ban, including some ex-Secretary of States, ex-Attorney Generals, ex-CIA directors. The Supreme Court was flooded with briefs by friends of the court. Amicus brief is basically another Latin expression for friends of the court, that we're urging the Supreme Court to find Trump's executive order to be unconstitutional. And the reason for that, and I'll walk through it a little bit, is that it is true that Chad was on the list and it was removed. And it is true that Sudan was on the list and it was removed. And it is also true that initially Iraq was on the list and then later on removed from the list. All of that is true. But it is not true that they were removed from the list per a transparent, accountable, public, legal process. In other words, what the proclamation says is that we would have a list of technical demands from each of the countries on the list to improve national security information sharing with us, the US. And when they comply with that, we remove them from the list. Sounds sort of reasonable. But what actually happens in practice is that the Trump administration refused to disclose to the district court, refused to disclose to the circuit court, and refused to disclose to the Supreme Court, even when questioned in oral argument about this, what were the exact record of accountability, what were the list of demands made from any country, and what were the list of compliances performed by any country that led to the removal. In other words, what removes the country and what did not remove the country seems to have been black back alley deals that could have to do with investments, money, corruption, who knows. But nothing to do with what the executive order says should take place. So that's one element. So the law reads one way, but we don't know, the law doesn't seem to be implemented the way it reads. Second, while there is a list of waivers, humanitarian waivers, there were a lot of evidence introduced during the oral phase of this case that no humanitarian waivers were indeed granted. In other words, that this waiver scheme is smoke and mirrors. That, in fact, there's one case introduced by, or at least testified to by one of the amicus briefs about a girl with a cerebral hemorrhage that, unless allowed to enter the United States for treatment, she would die. Her parents applied for a waiver, she didn't get the waiver, and she died. And there were tons of cases like that. So in other words, in fact, the Trump administration was not even able to testify as to an existing process for reviewing waivers. And in fact, there were some testimony, which I found rather interesting, in affidavits by Homeland Security directors, at this point X, because they were all fired, either shortly before or shortly after, who said that the orders from above were very clear that we are not to grant any waivers. So, in fact, so what do you end up with? Well, you end up with a ban in which the government says there is a review process, but in fact we have no evidence that there is a review process that does take place every 180 days. And one where the government says that there are waivers possible on a case-by-case basis, but in which no waivers in fact have been granted, or there are no plans to grant waivers in the future. But it doesn't stop there. It actually gets more problematic than this. Pair the Supreme Court decision, and this is something that all of you, it's remarkable how just the constant assault by this administration makes it very difficult for people to focus on the erosion of civil liberties, because by the time the Supreme Court decides this case, most people have moved on to the issue of separating children from their parents. And so the Supreme Court decision actually got very little attention. And now the ban is upheld as a constitutional matter, with people that were involved in this fight have moved on to the next fight, and the implications are rather profound. What the Supreme Court does and says in this case is that as long as you are able to discriminate through what is a technically correct process, as long as you articulate your language, as the dissent puts it, as long as you dot your I's and cross your T's. So as long as you give it to a good lawyer that can phrase the prejudice or the discrimination correctly, which, as I said, any good lawyer can do that for you. We, the Supreme Court, we will look the other way and pretend that we don't see a prejudice, we will not look further than the language right before us that has been handled by lawyers or crafted by lawyers, and we will foreclose the judiciary as an overseer of the potential for abuse of power by the executive or possibly even the legislative branches. So, in other words, the judiciary is out of the game. The effect of the Supreme Court decision is not just the Supreme Court, but the Supreme Court basically told all other courts in the United States, butt out. You don't get to issue injunctions against the executive if the executive articulates the law in a correct fashion. So, could the effect of this decision be that no Muslims from Yemen, Syria, Libya would enter the United States on student visa? Quite possibly. And in fact, the way the Supreme Court left it, the Trump administration can articulate, can reconstruct or can change the technical requirements for admittance or no admittance pretty much at will, as long as they do it through neutral language. So, can they, right now they're allowing people from Yemen and Libyans to get tourist visas, but not to get student visas. It seems to be completely inconsistent to the logic of, well, we don't want people who are threatening national security. Why would you threaten it on a student visa but not a tourist visa? The Supreme Court said, we're out of the game. You don't get to even challenge that in court because we trust the executive. Can Trump add new countries? Absolutely. According to the Supreme Court decision, not only can Trump add new countries, but maybe if something, may God forbid, happens, some crazy Muslim commits a terrorist attack, or Trump is running for re-election, Trump, by this decision, can add 5 other Muslim countries, 10 other Muslim countries, 20 other Muslim countries, all Muslim countries. The decision is crafted in a fashion which basically says the only power in the land that gets to challenge the executive order is the legislative branch. According to this decision, when honest, at least that's what the Supreme Court says, is that as long as it involves immigration law and national security, or as long as the president says it involves immigration law and national security matters, and as long as you phrase the law in the right way, that's fine. And the judiciary plays no role. I mean, even so, is it possible for Trump now to say, well, I'm going to pass a law saying no Asians? Not quite. Because if he puts Asians in the law, the Supreme Court would say that's not constitutional. But if he says no one from China, Korea, and Japan, that would be okay. And as long as you tie it to national security and so on. Now, a couple of other things to point out. Trump's lawyers repeatedly said in several courts, including the Ninth Circuit and before the Supreme Court, that the reason they included Libya, Syria, and Yemen, but did not include Saudi Arabia or Pakistan, which did not include Somalia, but then in fact banned entry of Somalis without it being on the list, is that the third presidential proclamation was issued after a thorough internal study of the visa processes of Muslim countries or countries in question, whatever these countries are, and that these were the countries that were identified as a security risk. Sounds reasonable, right? You do a study, you know what countries pose a risk because they have bad visa processes, they don't have good records, and you put them on, you flag them. The problem is that during the litigation of this case, repeatedly courts, including the district courts, several district courts, the Ninth Circuit, and even the Supreme Court asked about evidence of this purported study that was done to, in fact, vet out what countries pose a security risk to the U.S. And the Trump administration, in what is a very dangerous precedent for our democracy, said, no, we will not disclose the study. Basically, that it is an internal matter to the executive. We will not disclose it. Of course, I and anyone that has been following this knows that the reason they refuse to disclose the study is because there isn't one. They said there is, but there isn't a study. The only thing they produce is a 12-page document that just doesn't say anything at all. It's sort of and they produced it quite late, and it's just a very general, jargony thing full of rhetoric about how they must protect the national security of the U.S., blah, blah, blah. But it's not the study they were talking about, pursuant to which they identified what countries pose a danger. Now, why is this a dangerous precedent? Because the Trump administration has shown a knack for claiming to base its decisions on sources of knowledge or sources of information that they are privy to, but other people doubt, are puzzled by. So in other words, the whole fake news thing, we know what the true facts are. So the bad news, folks, is that per this decision, there's nothing stopping Trump at this stage, as long as he gets good lawyers to write the executive the next proclamation for him, or to revise the existing proclamation, nothing stopping him from adding as many Muslim countries as he wants, even all the Muslim countries, as long as he lists them all. He doesn't have to disclose any material that was claimed or purportedly internally circulated to verify the existence of deliberate, rational reasoning processes based on national security rather than animus. And the Supreme Court basically sends the message that if you don't like it, go to Congress and get it changed, but don't come to court. Now, I'm going to spend a little time talking about the dissent in this decision, because the dissent was rather refreshing in what it pointed out and what the Supreme Court very blissfully ignored. and I think quite correctly, the dissent points out that the issue here is not immigration law, and it's not really about national security for a lot of other reasons, other than the ones that I've mentioned. But it is about a core American principle. And the core American principle is the Establishment Clause, the First Amendment Establishment Clause, that our government will not establish a religion, meaning that our government will not favor one religion over the other. That's the Constitution. That, now, of course, there has been a movement within America to say, well, not when it comes to Christianity or the Judeo-Christian tradition, that the government can favor the Judeo-Christian tradition and that's okay. But the Establishment Clause, I mean, talking about the plain language of things on their face, the Establishment Clause on its face says the government shall not establish, favor a religion. It doesn't create a Christian exception or a Judeo-Christian exception. And the problem with the plain language approach taken by the Supreme Court is that unless you change the entire democratic character of the country, we are not yet at the stage where you can pass a law and say, I order the American people to hate all blacks, or I order all the American people to hate all Muslims. In other words, we have not, our democracy is still healthy enough that you don't get away with laws that are on their face discriminatory. But that there has been a long history in the United States, a long problematic history of laws that on their face appear non-discriminatory, but in fact discriminate. And in fact, according to American jurisprudence, there are two ways to verify that the government is discriminating. The first approach is called the intentionality approach. The second approach is called the desperate impact approach. It's a little bit of a law class, but there you go. The intentionality approach means that you look at evidence of a bad intention behind a neutral law. So for instance, when we in the United States passed something called the Mann Act. The Mann Act, on its face, seemed like a very reasonable law. It's it's a law that's read on its face like it's trying to prevent the enslavement of white women. But the intentionality behind the law, there was a lot of evidence that, in fact, the law was politically motivated and that it was designed so that you go after, we also, by the way, did this in the well-known Red Scare, laws that on their face look neutral, but we use them to get at Marxist or communist thinkers. So in other words, in the United States, we have a long history of, and again, the United States has a long history of good lawyering, or at least intelligent lawyers, whether good or bad or something else. But the intelligent lawyering is that we draft neutral things on their face, but the way that we interrogate whether this neutrality is in fact the case, true or not, is that we look at the historical record to try to see what was the animus behind passing the law. That's the first approach. The second approach is, in many situations, the people who pass the law do not disclose their intent, at least on record. They meet in private areas, they discuss things privately, and you have no idea as to what was the intent behind the passing of a certain law. So the way we evaluate prejudice or bias is to look at how the law is applied. Who ends up suffering because of the law? Does it disproportionately affect a certain ethnic group, or a certain race, or a certain religion? What the Supreme Court did in this decision is to not adopt either the intentionality approach or the impact approach when on an establishment clause issue. So basically to say, evidence of bias, we're not going to look either at what was behind the law as a matter of historical context, and we're not going to look at who's impacted by the law as evidence of bias. We're just going to take the executive at its word. The problem, though, is that this is a very unusual case because the executive, in passing even the third ban, could not shut up about how he wants this law to target Muslims and how much he hates Muslims. So I mean, you have an unusual situation that usually in the history of the US, people who pass discriminatory laws and never admit it. But Trump was admitting it left and right, up and down, everywhere. So, I mean, many of these examples I'm sure you already know, but for instance, before on the election campaign, you guys remember the story about some fictitious American captain who killed Muslims in the Philippines with bullets dunked in pig blood? Well, he repeated that same story again after the second ban and before the third ban. The statement that was, since most of you are Muslims, I would assume, I'll read to you this wonderful Trump statement that used to be on the website until taken down, but much later. I mean, website of justifying the first iteration of the ban and the second iteration of the ban, and even remained for a while on the website of the Trump administration for a short time after the third ban, and the lawyer at oral argument before the Supreme Court was not able to, in response to questions by justices who ended up joining the dissent, did not denounce this statement. So I'll skip around, but here's a part of that statement that officially justified the ban. Donald Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. I know that this was actually in writing. It sounds like someone tweeting, but this was actually a statement that was published. I mean, our president is not a very talented writer, but or whoever writes for him. Okay, so until our country's representative can figure out what is going on, I wouldn't let a student get away with writing what is going on in a paper, but okay. According to the Pew Research, among others, there is a great hatred towards Americans by large segments of the Muslim population. Most recently, a poll from the Center for Security Policy released data showing 25% of those polled agreed that violence against Americans here in the United States is justified as a part of global jihad, and 51% of those polled agreed that Muslims in America should have the choice of being governed according to Sharia. Sharia authorizes such atrocities as murder against non-believers who won't convert, beheadings, and more unthinkable acts that pose great harm to Americans, especially women. Goes on, without looking at the various polling data, it is obvious to anybody that hatred is beyond comprehension. The hatred of Muslims is beyond comprehension. Where this hatred comes from and why is something to be determined. until we are able to determine and understand this problem, i.e. Muslims hating America, and the dangerous threat it poses to our country cannot be the victim of further horrendous attacks by people that believe only in jihad and have no sense of reason or respect for human life, and so on. So, now, among the things that I just found rather interesting in the record, one of Trump's advisors testified in this case through, he was forced to, in an affidavit, that Trump called him in, I don't remember his name now, but anyway, it might come to you. Trump called him in and basically told him, quote, put a commission together, show me how to do this, i.e. to do the ban, the right way legally. Now, why is this important? Because it shows that the intent was for a ban, but that he basically brings in a lawyer who is an advisor and says, well, you know, do the legalese to make this fly. And yeah. So further, after this comes from Frank Wuko, that's the advisor that submitted the statement, that even after the third ban, which the Supreme Court decided on, he went on, that Trump told Frank Wuko that Muslim populations living under other than Muslim rule will necessarily turn to violence, that Islam prescribes violence and warfare against unbelievers, and that Muslims by and large resist assimilation in any Western society. So the dissent, which only, you know, it doesn't have any force of law, points out in this decision that effectively the legality is no more than a masquerade or a window dressing. That in fact, even after the third reiteration, what motivates this law remained an anti-Muslim bias, an anti-Muslim animus, and that it clearly evidences an executive that favors a religious faith over another, or clearly disfavors a particular religious faith, in this case Islam, and has not made a secret of hating it, and that it is extremely dangerous where we sidebar the establishment clause and say, well, you know, as long as you can do things in the correct lawyerly way, we'll ignore evidence that in fact the law is designed to put the government behind one religion and against another. The other thing that this ban does, and this is for me, is when something is challenged in court and passes, the history of this country shows that, and this has been like that now since at least the 50s. The Supreme Court plays a remarkable legitimating role in the society. So when the Supreme Court, for instance, first broke the taboo about racially mixed classrooms, or first broke the taboo about, in Roe versus Wade, about abortion, or more recently about homosexual marriage, the country tends to adopt, the social and political institutions of the country tend to accept what the Supreme Court says as sort of as social mores that are acceptable. Now, we have to consider what message did the Supreme Court send in deciding this case. And the message, I think, is quite clear that it is at least, if not okay, it's not problematic to hate Muslims as a group and to suspect Muslims as a group. Let me stop here and take questions. There's a lot that one could go on about, but I want to see what you guys are interested in. Does someone want to handle calling on people? Do I have to do it? You want to do it?
Okay.
No, I thought.
I'll go ahead and handle it as the chairperson or whatever, so.
Huh?
I'll take care of it.
Okay, you call on people.
I had a question, but I'll handle it anyhow. Okay, Kamal, go ahead.
You can call on yourself.
I won't just do it.
Thank you, Dr. Khaled. My question is, are there any ways that the law could be challenged to go back to a way by its implementation being unconstitutional in a manner that would make it an ineffective law because it's impossible to apply according to because it would violate a standard that's set elsewhere based on a different principle?
Elaborate a little, Michael.
So, on the one hand, it gives sweeping powers to the president, but the way it would be implemented, and I know that you're saying that it has given him all the powers to discriminate. Are there ways to challenge its implementation in a certain way?
Yeah, not.
That would make it ineffective, even though you can't. In a way, it would make it ineffective, even though it's not overturned directly.
No, not this one, because we've had exclusion, these are known as exclusion proclamations. And we've had exclusion proclamations in the past, not as sweeping as this, but we had an exclusion proclamation that applied to Haiti, to Cuba during Carter, to Iranians during Carter. Haitians, I think, was during Clinton, if I'm not mistaken. Anyway, and the way that these, again, they were much smaller, but the way that these exclusions work really make the admission process for people covered by the exclusion something of a black hole. So, presumptively, you don't get to come in if you are from a country on the list. And so Yemen, right now, Yemen, Syria, Libya. The Trump administration, and I'll give you an example, decided to make an exceptions for tourist visas, but not student visas and not other permanent visas, and not refugee status. There is no way to challenge this after the Supreme Court decision. Moreover, whatever regulations they craft for implementation or non-implementation is not reviewable. The Supreme Court has literally taken the rug out of the courts. What I fear is under the correct political circumstance, which I mean I can see that it would be expanded, and I can't conceive of because you don't have with laws that are so discretionary, that are subject to plenary powers. You often get your case dismissed right after you file it because you have no legal grounds to stand on, and that's what I expect is going to be happening after in a lot of lawsuits after this case.
So, if there's a ceiling, in terms of what we can do from the courts and legally, and the courts are saying you have to go back to the Congress and change the laws. What does that look like in terms of the need to change immigration law through the Congress? And should we be thinking more along the lines of creating that social change for that, as opposed to more lawsuits, more amicus briefs, more?
Yeah, I think after this decision, the door for lawsuits on this type of issue has been closed. I mean, if the Supreme Court has made it very clear that they thought the district court abused its discretion, and that's pretty big to tell a lower court that they abused your discretion. You abused your discretion when they issued an injunction in this case. So, and this brings in the next very important step. If the only answer left is congressional action, and here I want to be quite specific on a critical point that is often confused or obfuscated. Congressional action on immigration reform is one thing. Congressional action to affirm the ban as a violation of the Establishment Clause is another thing. So Congress can introduce a law that says, you know, as a matter of statute, as a matter of law under the Immigration and Naturalization Act, the INA, we think the president did exceed his powers because the Supreme Court cited to a certain section of the law and said that the Congress empowered the president to under that section of the law to do whatever he thinks fit in matters of immigration law. So it's possible that Congress would introduce a law saying, well, you're wrong, we didn't intend to give that much power to the president. That's one thing. It's quite another for Congress to come in and say, well, the Supreme Court decided, or they don't even need to refer to the Supreme Court, it was decided that this ban is not an Establishment Clause issue, because that's what the Supreme Court said. And we, Congress, say it is an Establishment Clause, or a violation of the Establishment Clause. Now, of course, the second is harder to achieve, but it is critical for our purposes, because the precedent you have here, and this, I'm sure as you know, since the founding of the United States, there have been, people who have insisted or wanted to co-opt the U.S. as a Protestant nation, as opposed to a Catholic nation, a Jewish nation, a specifically Protestant historical experiment. And at the same time, I think, fortunately, these are not the people who have prevailed in most of American history. And the folks that have prevailed were those who saying that, no, the United States is a nation without a religious identity means it is open to all religious identities. It represents all the religious identities within. What is really dangerous, I think, about the Supreme Court's decision is now you have a president who clearly espouses a religious identity and clearly opposes another religious identity. And the Supreme Court comes in and says, we'll just shut our eyes to it and plug our ears and pretend it's not there. That's disastrous. I mean, that's how you change the entire character of the civic character, the political character of a nation. People think that other countries slip into a disastrous autocracy, through some Hollywoodish evil plot where, the bad man is sitting there laughing maniacally. It doesn't happen that way. It happens exactly the way it's happening now. things that sound very sophisticated and lawyerly, but they erode our liberties step by step. So going back to the question, the issue that you raised, congressional action is a must. Now, how we get there is a much tougher question, because my sense, everything that I've read, everything that I've watched convinces me that lobbying has become a remarkably sophisticated art. And when I see Muslims do it, I'm not very impressed. We have a lot of good intentions, but we're hobbyists. We shoot from the hip and we fumble around. If I had a wishing ball, it would be that very wealthy American Muslims would hire a lobbyist to figure out how to make this a priority on the schedule of Congress, and to make the issue of Congress taking a stand on the Establishment Clause issue a priority. If the courts are not interested, and with the recent change in the coming change in the composition in the Supreme Court, forget it. It's gonna be a disastrous picture. I don't think in a democracy like the United States, I think the most valuable thing is knowledge, and you don't gain that type of knowledge without going to a lot of expenditure. Anyway, we do come carrying our immigration baggage of thinking the way knowledge comes the way our parents had it back home for free, and you sort of like sniff it out as you go about as a hobby. You don't do law as a hobby, you don't do lobbying as a hobby, you don't do Sharia as a hobby. I could go on about this forever, but that's my big peeve was Muslim community. Muslims can play dollhouse all they want, where they sit and pretend to be grown-ups and have real serious thoughts. Have fun, but you're not going to get anywhere.
Doctor.
Dr. Khaled, thank you for pointing out two important points, the intent and the impact, which is very clearly, in this case, discriminatory against Muslims and other minorities. We found that our president and other presidents, when they impose the issue of national security, even on things that has nothing to do with national security, lately, like the tariff, for example, on aluminum and steel, that no one can really stand against them, neither the Congress nor the courts, as you just mentioned. Case in point, the war in Iraq, when George W. Bush got unanimous support to go into the war, that everybody now realized that it was the wrong thing. So when the president claimed national security, who can really put the limit on that authoritarian power that's given to the president, and he can claim national security for whatever issue he wished to impose? And case in point, I think that case, Muslim ban, he claimed it as a national security. Tariff on aluminum and steel is a national security, so he can get away with murder. So who can stand up to that argument?
Every democracy in modern history that has become not a democracy, that has eroded into an autocracy, did so on the grounds of national security or some other ambiguous, vague cause. It's in the same way every teenager thinks that they they're so unique that they resemble no other. I think that's the way human beings are. They're like teenager vis-a-vis history. All people in history think that they resemble no other. And all nations that have slipped from some type of democratic order to an autocratic order have done so while there are basically an entire line of commentators and intellectuals who kept assuring people that we're different, we can never become a dictatorship. But people don't study history, and that's one of the biggest tragedies. The United States is not immune. But I want to distinguish and differentiate the issue of executive power on things like foreign trade or war powers. I don't want to get into that because that's a separate issue from an establishment clause problem. We're defending a very basic principle. If the government, as a matter of official policy, hates a religion, then we as common people, as public folks, we are put into a virtual confrontation with the government. If my government says, I hate your religion, or I hate your race, or I hate people who have noses that look like you, or whatever, something that is so fundamental, intrinsic to me, that puts me in, by definition, in a clashing course with the government. I become, by definition, identified as an opponent of the government. And when that happens, that's how a people becomes stigmatized and becomes hated and detested. So let's separate between the executive powers over commerce or war, and executive powers where the executive gets to stigmatize an entire minority, because that could have numerous repercussions for all the people who think the executive represents the government and represents America, and we must defend the value system that the executive represents. So for instance, when the president decides to go invade a country, all these young kids that decide to join the army and die, and they never, they believe sincerely that they're dying for America's freedom. Why? Because they symbolically they think that whatever position the chief commander takes embodies the identity of America as a nation. Now, imagine as the situation that we have here, that commander-in-chief is on record consistently and repeatedly saying, I hate a religion. I suspect a people. The impact of this will be to legitimate prejudice against Muslims, so that, and I'm willing to bet you that if you poll people now, among the average individual, the idea of banning people from various Muslim countries will no longer be as shocking as it used to be. It becomes more and more acceptable as you see people within position of power who are supposed to embody some type of moral example for the citizenry adopt a position. And the effect of the Supreme Court decision is that it will further the stigmatization of Muslims and make them the subject of increasing derision and prejudice. I know I didn't exactly answer your question, because your question is very broad, and it's about the executive powers over foreign affairs, and that's a much bigger issue that I don't want to veer to. we must, and what can we do right now about the issues that I'm talking about, the Establishment Clause? We have no other recourse other than Congress. What we do is we've got to matter in Congress. We have to make a difference, and we're not going to make a difference unless we put our money where our mouth is. If I had the money, I would hire lobbying professional lawyers to help me make an effect.
Sister Helen.
Thank you, Dr. Abou El Fadl. This is this important discussion. I wanted to ask you about any parallels or lessons learned from the Japanese internment. And as I
I'm happy you
understood,
raised that. Yeah.
I'm sorry?
I'm happy you raised that.
Yeah, as I learned that in that unfortunate time, subsequent to it, the government, there was an apology and monies compensated to those Japanese families that were interned. So I would like your thoughts on that.
Yeah, actually, I'm happy you brought this up because the Karamatsu family who brought the actual case, they actually filed an amicus brief in this case against the ban. And the amicus brief was really good. I mean, they clearly drew the parallel in what happens when you stigmatize a people and dehumanize a people and so on. Two things. One, the dissent, Justice Sotomayor, there are two dissents in this case, and he wrote one of them, in fact says that, like the Karamatsu case, Karamatsu is around the time, for those who just don't know, around World War II, the government decided to put all Japanese, including US citizens, in internment camps and concentration camps, basically. And it was a very tragic experience because people lost all their livelihood, lost their properties. There were some, the camps were not, they were prepared very quickly. And like what we're doing with children in our immigration detention centers right now, our media was talking about these camps as resorts, while the conditions in the camps were horrendous. Anyway, so the dissent of the case says, you know, this is like a repeat of history, because like in Karamatsu, basically what the court said is that trust the president, we have to defer to the president in circumstances involving foreign policy, national security, and war powers. And this deference bars us from looking at whether the law, which was neutral on its face in many ways, in fact, you know, except the law was phrased in terms of people who were either Japanese nationals, joint Japanese nationals, or at one time held Japanese citizenship or were the descendants of Japanese citizens. So, and it said that the Karamatsu case that the government is plagued by spies from Japan and can no longer administratively figure out who's a spy and who's not, so we just have to detain everyone. And the Supreme Court, in a very shameful decision, basically came in and, like this case, said, well, we've got to trust the executive on issues that the judiciary is not competent and is not positioned to decide. And the Supreme Court said, we're not going to look beyond that. The dissent in the ban case, our case, in fact says, you know, Karamatsu has gone down in infamy as a major failure of the judiciary. And likewise, this decision will go down in infamy as, again, a major failure of the judiciary. The majority does something that I thought was very interesting and sort of curious. For many years, definitely when I went to law school and well beyond, Karumatsu was never overruled officially. So we didn't know whether Karumatsu is good law anymore or not because the Supreme Court never officially overruled it. Oddly enough, the Supreme Court in this decision takes the opportunity to officially overrule Karumatsu. Now, so they say, oh, and by the way, Karumatsu was wrongly decided, it was wrong the day it was decided, and we distance ourselves from the Karumatsu case. There are two ways that one can read this. Possibility number one, let's call it the legal realist possibility, is that the Supreme Court knew that it was dropping the ball on Muslims, that there's plenty of evidence of an anti-Muslim animus on part of the Trump administration. The Supreme Court refused to look at it. The Supreme Court felt cornered by the fact that the dissent is saying, this is identical to Karumatsu, you're doing it all over again, shame on you. So they took the opportunity to overrule Karumatsu as a sort of an offering, if you will, that, oh look, we're not that bad, Karumatsu is not okay, but this one is okay. That's the first possibility. Second possibility, and we'll call that the legal idealist possibility, is that the Supreme Court meant to send a message to the Trump administration that it's okay if you want to declare Muslim or people from Muslim countries inadmissible, but if you're thinking of interning Muslims, well, we're overruling Karumatsu to make it clear that you can't do that. I would probably bet on the first option rather than the second. I don't think this Supreme Court, this present majority the way it is, would have intended to sort of send a message to Trump that you can bar Muslims from entering, but you can't intern them. I think that's probably too charitable an interpretation. But if you're an optimist, you can take the second. I don't care. I guess we will find out. I mean, because I do think with this administration, all it will take is another serious terrorist attack. And American Muslims are going to, all the stuff that I've been preaching about for now 20 years, put your money where your mouth is, get serious about education and about knowledge and about institutions around in society, and everyone has been ignoring me, alhamdulillah. I think they will get a very rude awakening. Because this administration clearly has an evangelical Christian agenda, wants the Christianization, and there's a book by Denise Spielberg that tells you the story of even as in the 1700s and the issue of whether Islam should be allowed to become a part of the American tapestry goes back to the 1700s in this country. And back then people like Thomas Jefferson said, yes, why not? But so many Christian theologians, especially Protestant in this case, did not want Catholics, did not want Muslims to become part of the American tapestry. And we've been fighting the same legacy over and over. Catholics is not sexy to hate them, not as sexy to hate Catholics as it is to hate Muslims. But maybe we need growing pains, I don't know. Maybe we need to suffer to learn. I'm a very cheerful, optimistic person. But I'm an academic. I just evaluate history and predict how things are going, and leave it at that. Any other questions?
We have questions.
I'm going to follow up with what you said and be the optimistic one instead of going on that. As you said, it's not only I feel in spite of everything happening and everything that we can get more groups with Muslims, because what's happening is not only against Muslims, but it's really against the constitution of this country. It's not only against us. Even if they call it Islam and they say words like jihad, that they have no idea what jihad is about, or Sharia. Even Muslims are struggling with words like that. Now they pretend they know those words. Why don't we get to Protestants? Why don't we get to atheists? Why don't we get to liberals and try to make something out of this?
One of the most amazing things are the number of people that sided with Muslims over this ban.
Yeah.
It's, reading legal stuff is not very exciting, but it actually warms the heart when you read all the amicus briefs that were filed in support of Muslims and against the ban, all of which the Supreme Court ignored, by the way, completely ignored. But, what do I tell you? Clearly, if you're smart and racism and bigotry will not stop at Muslims. If I'm a Jew, I would be worried because your turn will come. Traditionally, historically, whenever a nation Christianized itself, among its first victims are Jews. And so if you think, people like Daniel Pipes, that seems to think that you can target Muslims and then Jews will be fine, I think history will provide it with a very rude awakening. But I'm not interested in the kumbaya moment. Kumbaya is what it's called, right? It doesn't interest. It doesn't warm my heart to go to a demonstration and find all types of people who are not Muslim supporting me. I want practical, pragmatic results, and practical, pragmatic results means working within Congress with a specific target. And I'm not, if someone, because this is the way people prevent you from actually getting anything done. They'll say, oh, well, join us in our work for a comprehensive immigration reform. Comprehensive immigration reform, that's an entirely different battle. What I want is Congress basically to come back and send a message to the Supreme Court, the way you interpreted this is wrong. It is not all right for the executive to have an anti-religion, anti-Muslim animus, or whatever particular animus that the president might have. In this case, it was clearly anti-Muslim, and for the Supreme Court to say, well, we can ignore it as long as the plain language of the proclamation doesn't repeat that prejudice. There's only one institution that can come back and say that's not the right way to approach issues of bigotry and prejudice, and that's the legislative branch, because Supreme Court said we're out of the fight. Either that, much harder, trying to, that's much harder than to elect a president that will change the composition of the Supreme Court so that, because who knows who's going to retire next or who's going to die next, and this president seems like he's going to be reelected if things keep going the way they are. And I think during his re-election bid, he's going to add more Muslim countries to that list. And he's going to, in immigration practice, we used to get religious visa very quickly. I mean, when an Islamic Center wants to get an imam, and now I'm noticing massive delays and denials when Muslim organizations want to get or apply for a religious visa for someone. It used to be the easiest visa in the world. At the same time, the data is that Muslims are the only group that are having problems getting a religious visa, with denials on very ridiculous grounds like you didn't submit, documentary proof of the previous employment of your previous imam who's now dead. Things like that I've seen in denial letters. So I don't know. I'm not looking for. Sorry, that's my cane. Sorry, thank you.
We have the mic over there.
I don't want to come beyond.
My point was just to reach to other groups. We don't have to reach out only Muslims. If somebody else is more philosophical, more intellectual, more able to
we
reach,
have to become part of the fabric and work with
you say constitution and
other.
I hear prostitution, I'm not joking, I mean, it's to that point.
I don't. I mean, I have to admit to you, I love the Constitution. I think it's a.
I love it too, but that's what I hear, I keep on hearing the other.
And I think it really saddens me. I mean, you've got this this Thomas Justice, files a concurrence in this decision and says courts should not have the power to issue injunctions. It's weird, truly weird, and cites the practice of courts of equity and the British Chancellor. I mean, some really weird stuff that we see these days. But you're right. We should work with and ally ourselves with.
Yeah, I think it's
people
more
who are
an American
like-minded.
problem than just Muslim problem.
I agree.
Dr. Fadl, why is it the case that textualist or originalist interpretations tend to be of a conservative nature? They just sort of choose to omit whatever it is that they please and then claim the grounds that this is what the law states.
I mean, that's a bigger question. So I'll answer the part of it that I think because I mean, originalists and textualists are two distinct, separate schools, and it's a huge question of what is textualism and what is the original intent school and so on. But I'll tell you, this decision, the majority claims that it is adopting a textualist approach of reading the letter of the law and not looking beyond that, not looking to the legislative history, in this case the proclamation history or the executive order history, not looking at anything beyond the letter of the law. Now, the problem though is, and again this is something that the Sen did point out, this same court has had a very different approach when it encountered legislatures or lawmakers that were motivated by an anti-Christian animus. We saw a very different approach. So in the case of that baker refused to serve a gay couple, the Supreme Court emphasized in its decision that the city commissioners who wanted the baker to serve the gay couple or be closed down, on the record had a very anti-Christian attitude and had made a lot of anti-Christian comments. And the Supreme Court focused on that in saying that the First Amendment rights of its maker was denied. Now, why does the Supreme Court in one situation look at the historical context of an executive action, or possibly legislative action even, in order to decide constitutionality or not, while in a different context, in the context of Muslims, ignores the historical context and says, no, the historical context doesn't matter. Is it inconsistent? I think so. Is it a contradiction? I think so. And I think that the Supreme Court is this Supreme Court in particular, it's the most Christian Supreme Court we've had. These are not, I mean, the majority of the Supreme Court seems to be fine with the idea of a distinctly Christian Protestant nation. And that will change the character of the United States. It will make it a very different country, especially if the Kennedy was often the swing vote between the sort of solidly very Christian America camp like Thomas and those who, a neutral America camp, and Kennedy would swing back and forth. Now Kennedy is retiring. That means Trump gets to appoint probably someone like another Thomas. And that's going to affect, for a long time, the way the Supreme Court defines this country. I know I didn't answer your question about textualism, and because that's that's a seminar. It's not a class.
Assalamualaikum, Dr. Fadl. Thank you so much for the enlightening talk. I have a quick question. Does the third Muslim ban has the same limitation and impact, or will be practiced by Trump like the NCR system in 2002 during George W. Bush's presidency?
No, it's a very different structure than Bush's executive order, because Bush's executive order was narrowly tailored to serve certain purposes. This one is quite broad, and it's broad for people from certain nations, Syria, Yemen, Libya. And my guess, what I expect is going to happen, is that Trump is going to add more countries. And there's no evidence. Listen, according to the executive order, waivers are going to be decided case by case. But till today, and I checked this morning, no guidelines have been provided by Homeland Security as to what is the process to get these waivers. So what lawyers have done is literally just write their own material to apply for a waiver, but in disproportionately, the only waivers that seem to have been granted were granted for people that seem to have a relationship with the American government, like a guy that used to work for Egyptian intelligence and, seems to, he's Egyptian military and, they get, something like that. Or I'm sorry, not Egyptian, Libyan military, I was thinking, related to the Haftar forces, some shady, weird guy that had a relationship with Haftar. But nothing is disclosed about these cases. They just, are allowed to come in, they're set up. But officially, there is no official implementation of the waiver process. And that's why two dissenting judges emphasize this point, that it seems like this ban is a blanket ban and the waiver scheme is a sham. Do you see what I'm saying? I'm seriously, I think in order to, because right now hostility to Islam sells, I'm seriously worried that Trump will add more countries to that list, and there's nothing that would stop him from doing that after this decision.
So it seems that other religious groups and other minorities are very good at organizing and pulling the right people together to get something accomplished. So if we're talking about the need to target Congress and, deal with this issue of the Establishment Clause, who within our community, the Muslim community, would be the best to lead that charge? Or if there isn't anyone, who do you think would be the right people to be really able to put a smart effort together?
Obviously, the only one I know about is MPAC. But again,
we need a Muslim millionaire.
yeah, again, MPAC, not to, that does not imply that MPAC has the know-how to lead a lobbying effort of the scale that I am thinking of, to in fact get Congress to act on an Establishment Clause issue in a political environment which is hostile to Muslim organizations. So it's like you often do in business when you can't do business under your own label, so you create these little satellite companies that I think Muslims have to be smart in thinking, it's very difficult to, there's even now a sort of a stigma for certain lawmakers to even entertain an audience with Muslim organizations. So Salam is right, we need millionaires to provide the funds so that an organization like MPAC can hire a professional lobbying organization that trains them and that works for them and that so on. I'm maybe I'm just too jaded, but I'm not impressed by any of the Muslim players in the field. Salam is an exception, of course, because he's a buddy. But I'm not impressed by the way it's. There's a certain level of professionalism and a certain level of playing by the competitive rules of the game in mainstream society that Muslims try to shortcut by creating their little ghetto institutions where they can feel that they're important. They're important within their institutions, but completely unimportant outside their institutions. And that's a very serious problem.
Sorry, but as a follow-up too, because if the millionaires don't come, then does that mean that we are just going to supply, there has to be some alternative? So how can people get involved short of millionaires showing up on the stuff?
I don't know. Salam, do you know?
The short answer to that, and this is the lesson of Japanese Americans, is that they built coalitions. They didn't get the U.S. government to apologize on their own. They built friendships with powerful groups. And I think that's also the lesson of the Prophet ﷺ, that he built relationships with powerful people to protect the Muslims. And I think that's what we are now. Short of the money, short of the funds, short of the, that K Street type lobbying firm that we can partner with, we just have to work in building coalitions around the country. From immigration experts to peace and justice to civil rights people, I think there is that potential, but basically short of getting that legal change now, we need a social movement to redefine what America is. And I think that's the coalition around which we need to build.
Last question.
Yes. What is behind all this Islamophobia at this time, what is causing behind all this Islamophobia at this time? You know, what's leading to all this thing?
What's causing it? I mean, it's a really big question. I mean, I often wonder, does Trump really care enough to hate Islam as much as he says he hates it?
He likes to be racist.
Yeah, I mean, of course, he's done business with the Saudis and the Emiratis for ages. And he's made so much money from the Saudis and the Emiratis and so on. But I think the issue is this. There has been a resurgence, not just in America, in the entire West, Europe and America, of nativism and populism. And what that means is sort of a movement that embraces a certain ethnic identity to the country. It doesn't want immigrants that look and act differently. We went through a period in which the talk of the town, sort of the cool talk, was about pluralism. And that was the 80s and early 90s, but you don't even hear, pluralism is not necessarily a sexy word anymore. It's sort of dated. And the part of it is an inevitable, not that surprising reaction to the rise of immigrant numbers and, to be blunt about it, a racial group, whites mostly, worrying about losing their majority status within their countries. Islam has been traditionally, I mean for centuries, vilified and demonized by so many, in the Western imagery, by so many writers, so many artists, so many politicians, and racialized. Islam has always been associated with some retarded race, whether it's Turks or Moors or Saracens or whatever they're called. And so you have some of that, some racism mixed with some nativism, the idea that unless we embrace our Christian identity, then we might wake up someday and find that America has become Muslim, and you know, what the horror, oh my God, you know, that type of thing. If you want a more concrete, tangible answer, I think Islamophobia, the one that we're experiencing right now, was artificially, it's like when you add an accelerant to a fire. I mean, a fire will burn at a certain rate, but if you go and put gas on it, it will burn much faster. And the Islamophobia industry, where certain people with a lot of money invested in an Islam-hating project, I mean, literally gave money to individuals initially like Bernard Lewis and Daniel Pipes, and then eventually people like Robert Spencer and so on, to fund an industry that we refer to as an Islamophobia. Part of it is a misguided idea that in order for Israel to be safe, this is a Daniel Pipes part, in order for Israel to be safe, we need to turn the world against Islam because otherwise Muslims will pose a danger to Israel. Another part of it is Christian evangelism. The idea that Muslims, and this is a very old idea, that Muslims are basically the coming army of the Antichrist. You know, even if you look at documentaries, if you look at images of the forces joining the Antichrist, they look Muslim. And so we're sort of helping history along so Jesus can come back and smite the Antichrist and smite all Muslims with the Antichrist and so on. From my perspective, it's hard to take this stuff seriously, but if you want to see that it's as serious as death, just watch some of the Christian channels late at night. I mean, they just go on and on and on and on and on and on about the coming of Christ and the role of Israel and Muslims as how they're, Muslims are all going to join the armies of the Antichrist everywhere. It's nuts. I mean, it's nuts from my perspective, but people get very excited about it.
All right. Thank you so much.
Okay, guys, thank you.